determines a dispute based on merit. So we have arbitration, we have mediation, we have reconciliation, and we have agreement. I think that one is arbitration. So the three major types of alternative dispute resolution mechanisms that we looked at. So we looked at arbitration, we looked at mediation, and also we looked at negotiation. So we looked at negotiation, but of course there are others. For example, early expert neutral evaluation, or we can have traditional methods whereby, for example, you can have elders in the community having to resolve any kind of dispute. Dispute. So arbitration is whereby we are saying that there'll be an impartial third-party person who will be able to determine that particular dispute. So here you go before the arbitrators. You go before the arbitrators who will be able to resolve the matter. So they'll be able to resolve the matter. You go before the arbitrators who will be able to resolve the matter. So there are three main types of dispute resolution mechanisms. So we can have arbitration, we can have mediation, but of course there are others. So there are others, for example, early expert neutral evaluation. So you can have, for example, others. We can have an ombudsman. We can have early expert neutral evaluation. We can have a mini trial. We can have expert determination. We can have adjudication. We can have traditional methods or customary dispute resolution mechanisms, whereby you go, for example, before the elders. So when you talk about an alternative dispute, it is an alternative to resolving a dispute rather than having to go to the court. You'd rather opt for these methods we've talked about or mentioned here, rather than having to go to the court. So that's why they are talking about them being actually an alternative way of how you can be able to resolve a dispute. So when you talk about an arbitration, so it is where we have an independent arbitrator. We have an independent arbitrator who will basically be able to make a determination by giving a ruling or of a matter known as an award. So you'll go before an arbitrator who will basically maybe be appointed by the affected parties under the dispute. So it is an out-of-court method of settlement of civil disputes by arbitral tribunals, which make the arbitral awards as opposed to judgments. So they don't make judgments or rulings like in a court of law. So they give a decision known as an arbitral award. So that decision that is normally given by these arbitration bodies, it is what we call an arbitral award. So the law relating to arbitration is contained in the Arbitration Act. Under the Act, an arbitration agreement is an agreement between parties to refer to arbitration all or certain disputes arising between them. So the principles of natural justice in relation to arbitration proceedings are a fundamental requirement of justice in deciding a dispute between two parties or more parties. So they'll be able to apply what we call the fundamental principles of natural justice. So when you talk about the fundamental principles of natural justice, now in this case, we could be talking about, for example, the right to be heard. We can talk about, for example, right to be heard. Those are just examples. Right to be represented, right for representation. We can be able to talk about right to present evidence, or any other relevant information. So right, for example, to seek for an adjournment, right to seek for an adjournment. So right to seek for an adjournment or postponement. So right to seek for an adjournment. So that is what we mean by the right to seek for an adjournment. So when you are being heard before this arbitration body, you can be given the right, for example, to present your evidence, or maybe the right to be able to be represented by a person. So you cannot be denied that right, because those are the rights of what we call the principles. They are the rights of what we call the fundamental principles of natural justice. So if you go to any court in this case, you, for example, have the right to be represented. So they are usually actually applied by the arbitration bodies. So the arbitration body will have to be set up. It will have to be set up by simply, in this case, the parties affected by that particular dispute having to propose as to who will be able to sit on this particular arbitration body. So so the matter can be referred to the arbitration maybe by the parties themselves, or by an act of parliament or a law that is in place, or a court of law with the consent of the parties to the dispute. So the parties to the dispute, arbitrators may be appointed by the parties to the dispute, a third party as agreed by the parties, or maybe the High Court on application, So you can be able to see under arbitration is whereby we have a third neutral party who will be able to give what we call an arbitration award. So the third party is the one who actually gives out the verdict. So if you look at that question in this case, so they wanted us to be able to mention the kind of alternative dispute resolution mechanism whereby there be an impartial or neutral third party who will be able to make the determination. So under mediation, so we don't have the third neutral party will be there, but of course now in this case, it won't actually make the determination. The resolution, so basically the decisions will be decided upon by the parties affected with the disputes or under the dispute. So we have mediation. So we have mediation as one of the alternative dispute resolution mechanisms. So mediation, so I think it's here. So mediation, it is an informal and confidential way for people to resolve disputes with the help of a neutral mediator who is trained to help people discuss their differences. The mediator does not decide who is right or wrong or issue a decision. So it doesn't actually basically decide who's actually right or wrong or issue a decision like under arbitration, where the arbitrator gives an arbitral award. Instead, the mediator helps the parties to work out their own problems. So he helps them to work out their own problems, but he doesn't actually give the verdict or the solution to the problem. So he just creates an environment. So it's known as mediation. So that kind of process is actually known as mediation. So we have, for example, negotiation. So negotiation is whereby, for example, the parties just agree to meet, and of course they negotiate under any kind of dispute and try to resolve it. So they don't involve another person. So it has been defined as any form of direct or indirect communication whereby parties who have opposing interests discuss the form of any joint action which they might take to manage and ultimately resolve the dispute between themselves. So here there is no third party involved. You can be able to see under mediation, under arbitration, there's a third party who's actually involved. Under negotiation, no third party is actually involved. So the parties by themselves are the ones who will be able to resolve the matter. So they can just decide to meet and take action as to how they'll be able to resolve their own disputes amongst themselves. So negotiations may be used to resolve an already existing problem or to lay the groundwork for future relationship between two or more parties It is characterized by preeminent mode of dispute resolution, which is hardly surprising given its presence in virtually all aspects of everyday life, whether at the individual, institutional, national, or global levels. Each negotiation is unique, differing from one another in terms of the subject matter, the number of participants, and the process used. So these basically are processes we are likely to experience, for example, on our daily life, maybe at our workplace. So you could have maybe differences, so you can decide as to how you can be able to resolve them or negotiate and actually agree. So it actually basically present, it is present in our daily life. It is not surprising to find that negotiation can also be applied within the context of other dispute resolution processes, such as mediation and litigation settlement conferences. So that's what we mean by negotiation. It is voluntary, so no one is usually forced to. You basically come voluntarily to meet the opposing side. It can be bilateral or amongst many parties, multilateral. So it can involve 2, 3, or maybe a dozens of parties or a dozens of parties. It is non-adjudicative. It involves only the parties. The outcome of negotiation is reached by the parties together without recourse to. So there's no neutral third party. There's no neutral third party under negotiation. But for mediation and arbitration, a third party is actually involved. A third party is actually involved. So maybe they could twist the question and ask, which amongst these ones doesn't actually involve a third party to resolve a dispute? So maybe they indicate there may be mediation. So mediation, they don't actually involve a negotiation, they don't actually involve a third party. So negotiation, they don't actually involve a third party. So under mediation, there's an arbitrator, there's a mediator. Under arbitration, there's actually an arbitrator. There's actually an arbitrator. So there are the other methods we've tried to mention. So maybe it's good you understand them. For example, an ombudsman. So an ombudsman is a person who investigates complaints and attempts to assist the disputants to reach a decision. Usually, this is an independent officer of the government or a public or quasi-public body. An ombudsman can be classified as an ADR mechanism. So it is simply a person who's actually been appointed to carry out investigations and, of course, assist the persons under the dispute to resolve it. So early expert neutral evaluation. So early neutral evaluation. So this is where before you go to the court, you look for a third party who can be able to advise you. So this is where the parties to the dispute consult a third party with regard to the dispute. The third party then advises them on the likely outcome of the conflict, should it be referred either to the courts or other formal means of dispute resolution mechanisms. So most advocates usually carry out E&E. So you seek for maybe consultation or actually advice before you proceed to the court. So then the lawyer or basically the advocate advises you that if you proceed to the court, this is likely to be the verdict. So instead of having to go to that route, you can be able to resolve it like this. So you don't go to the court because you're looking for the alternatives of actually, instead of having to go to the court, you can look for an expertise advice. So a mini trial. So this is where now before formally, the proceedings actually commence. So it is where in a judicial, it can either be judicial or private. It is similar, almost similar to E&E above. In a judicial mini trial, the parties are already in the court and they go before the judge. The synopses of their cases are presented and the judge advises on the likely outcome. So the judge advises on the likely outcome quite early enough. So if one is found to be guilty, so this will be the repercussions. This will be the penalty. So the judge mentions that during the mini trial, or maybe they can say the pre-trial. So the private mini trials mostly occur in large organizations where members or senior managers of an enterprise receive a summary of the disputes and essentially suggest ways of resolving them. So they have gone to the court, they have seen the mini trial, so they have been advised by the judge. So they'd rather opt to resolve their own commercial disputes by simply maybe looking for an alternative. So the judge advises on the likely outcome of the matter before it goes to trial. So there'll be what we call a mini trial. But then we have expert determination. So it is where the parties to the dispute appoint a third party who makes a binding decision upon hearing the parties. He must be an expert and makes his decision based on such expertise. His decision will actually be binding. So it is where you seek an expertise advice, whereby you know a particular person can be able to resolve such kind of a matter. He has the knowledge of how you can be able to go about and get a solution. Maybe it is a dispute under maybe a contract. So you know the repercussions, but you look for a person to be able to advise you how you can be able to go around to resolve the matter under that particular kind of dispute. So you look for an expert. You look for a counselor. So people go to the counselors. So if they have problems, maybe at their home, so they can go to a counselor who has expertise and basically gives a way forward. Or maybe you go to the most senior member of the family. You will go to the most senior member of the family. Then the most senior member of the family basically gives directions as to how the matter will actually be resolved. So you are taking short notes. So I can see you are taking short notes. So I don't know, you are up to which point. I don't know, you are up to which point. But I've said that expert determination, it is where the parties to the dispute appoint a third party who makes a binding decision upon hearing the parties. Then we've said a mini trial. It is where the judge advises on the likely outcome of the matter if it was go to trial. It is where the judge, so you can be able to summarize it like that. It is where the judge advises on the likely outcome of the matter if it was go to trial. It is where the judge advises on the likely outcome of the matter if it was actually to go to trial. Early neutral evaluation, where the parties under the dispute consult a third party with regard to the disputes. And then the third party actually advises them on the likely outcome. Where the parties to the dispute consult a third party with regard to the disputes, and the third party then advises them on the likely outcome, e.g. an advocate, for example, e.g. an advocate. Then we have adjudication. It is where an adjudicator is appointed to settle disputes. He is appointed by a neutral third party entrusted to take initiative in ascertaining the facts and the law relating to the subject matter in question. So an adjudicator is actually appointed by the responsible party. So for example, now in this case, you can be able to talk about maybe there's a dispute maybe in the cabinet. So the president in this case actually appoints maybe the senior most cabinet member to be able to resolve such kind of disputes. So he's appointed by a neutral third party entrusted to take an initiative. That third party, when he sees there's a problem in government functioning as a result of that dispute, he should take the initiative. Who is it? It is actually the president. So he chooses the senior most cabinet member to be able to resolve such kind of disputes, to become the adjudicator. So it is where an adjudicator is actually appointed to resolve a dispute. Then you have traditional or customary dispute resolution mechanisms. So this is where you go to the Council of Elders. go to the Council of Elders. So each and every community has the Council of Elders. So in this case, they are usually recognized as some of the board organs that can be able to resolve disputes in the communities. So they are recognized by the Kenyan courts, just as African customary law as bodies that can be able to resolve disputes. So you can go to the Council of Elders. The Council of Elders. You can go to the Council of Elders, to the Council of Elders. So those are the methods of dispute resolution mechanisms, or how you can be able to resolve disputes. So there, I think they had mentioned arbitration, mediation. They have even mentioned the reconciliation. So reconciliation can almost be similar to what we are calling negotiation. So you agree to reconcile. So by agreement, you can simply craft down an agreement as the parties that there'll be terms that you'll be able to follow in resolving the dispute. So by agreement amongst the parties. So you don't have to involve a third party. You don't have to involve a third party. Then there is so there's question number 52. So in most civil law jurisdictions, so which of the following procedures may a civil appellate court generally perform? So in most civil law jurisdictions, which of the following procedures may a civil appellate court generally perform? So you're talking about interview more witnesses, enter judgment if law issues are correct, collect more documentary evidence. So in a civil law jurisdiction, it is where we say they apply which kind of judicial process. So they apply the judicial process known as inquisitional, whereby they do a lot of inquiries and actually investigations. So they do what we are calling inquiries and investigations. So just remember that we said, don't forget again, under a civil law jurisdiction, they actually apply that system of inquisitional, whereby they do investigations. So they carry out investigations. So the court is actually able to carry out its own investigations, and of course, before they give out the verdict. While in a common law jurisdiction, they apply that other one known as adversarial judicial process. They apply what we call adversarial judicial process, whereby under adversarial judicial process, the parties are actually left to argue and present the evidence by themselves, by themselves. So you want me to talk about the negotiating styles? I think they are here. Negotiating styles. So you have positional best, So we have positional best or competitive. So positional best, we have this one, positional best or competitive. Then we have interest best. So positional best is simply whereby you are negotiating, but you've taken a position. So the one who's actually very superior is likely to take up a position and stand with it. So you'll take advantage of the weaker person or the weaker party. Maybe it could be between the employer and the employee. So the employer actually takes a positional best, whereby he knows he's quite superior, and therefore he's just basically going to take advantage of the inferior party. Interest best is whereby you balance in this case. The interest of the employee is taken care of. Also, the interest of the employer is actually taken care of. So maybe it is, for example, in this case, negotiating as to when probably maybe a person can be able to take up his or her leave. So there is the interest of the employer, whereby, for example, now in this case, it is a high season whereby they have a lot of clients or customers. So in case you go for leave, it will hamper their operations. So on the other hand, also in this case, the employee is actually basically looking at that particular period whereby he has a particular function or maybe ceremony to be able to prepare for. So you need to be able to take care of the interest of the employer and the interest of the employee, and then come in the middle and actually agree exactly when the leave can actually be taken. So you don't take a position. So if it is position of best, it simply means that the interests of the employer will be just be taken care of. Now, in this case, you will not actually go for the leave. There will be no any form of having to agree and coming to having what you are calling a middle ground. So in a competitive or position of best approach, the parties try to maximize their returns at the expense of one another. So they will use a variety of methods to do so and view the interests of the opposing party or parties as not being relevant, except insofar as they advance one's own goal, maximizing on their own returns. Competitive bargaining has been criticized for its focus on specific positions rather than attempting to discern the true interests of the parties. Among the criticisms which have been leveled at the competitive model are the tendency to promote brinkmanship and to discourage the mutual trust which is necessary for joint gain. Interest-based, it is where cooperative or problem-solving negotiation starts from the premise that the negotiations need not to be seen as a zero-sum situation, i.e., the gains of one party in the negotiation are not necessarily at the expense of the other party. So the common interests and values are stressed, as is the use of objective approach. And the goal of the negotiation is a solution that is fair and mutually agreeable amongst the parties. So it is where you don't, for example, now just protect your interests. You consider the other party. So you consider the other party's interests also and try to balance so that you can actually come to a middle ground. You don't take a position and stand with it. So you listen to that other person's interest or maybe reason as to why, in this case, he wants you to basically maybe do as he or she actually wishes. So it is actually interest-based. I take care of the interest of the other party. He also takes care of my interest under this particular dispute so that we can be able to meet at a middle ground. But if it is actually position-based, I simply take my position and actually stand with it. I don't want to basically negotiate. You negotiate based on just basically protecting your interests. So you negotiate on the basis of actually just protecting your interests and not the interest of the other party or not considering the interest of the other party. So it is positional based or competitive based. So you can have interest based, or maybe we can have what we call positional based, or we can have what we call positional based. So those are the two negotiating styles or negotiation styles that we can have, the negotiation styles that we can have. So I think we were looking at adversarial judicial process and inquisitional judicial process. So whereby we are saying under civil law jurisdictions, they'll use what we are calling inquisitional, or inquiries or investigations have to be undertaken before the judge can be able to make or come up with a verdict. But under common law jurisdictions is whereby you are saying that in this case, let me get the question first. So let me get the question. So in civil law jurisdictions, which of the following procedures may a civil appellate court generally perform? A civil appellate court generally perform. So here's where we are saying they do a lot of inquiries or investigations. So they do a lot of inquiries or investigations. So in most civil law jurisdictions, which of the following procedures may a civil appellate court generally perform? So interview more witnesses, enter judgments if law issues are correct, collect more documentary evidence. So collect more documentary evidence. So, and that is, I think, what we saw. It is normally carried out under inquisitional judicial process. So I think we can just be able to review or remind ourselves there. So inquisitional judicial process, so what normally happens there? So it is associated with the civil law legal system, and it has existed for many centuries. It is characterized by extensive pretrial investigations and interrogations with the objective to avoid bringing an innocent person to trial. The inquisitional process can be described as an official inquiry to ascertain the truth, whereas the adversarial system uses competitive process between the prosecution and defense to determine the facts. The inquisitional process grants more power to the judge. So once the judge is actually able to see that the facts are maybe according to what is actually provided for under the law, then he'll actually be able to make the ruling or the judgment. So the judge who oversees the process, whereas the judge in the adversarial system serves more as an arbitrator or an arbiter between the claims of the prosecution and the defense. So I do a recap on the civil court matters. Personally, I have not been in class and would love to understand. So civil court matters. So we are saying, so there are two legal systems that here we are actually trying to emphasize, and that is the main focus of study in this particular unit. So we are saying we have a civil legal system, and a common law legal system. So that is the first thing to be able to notice, that we have a common law legal system and we have a civil law legal system. So under a common law legal system, they apply what we call the adversarial judicial process. Adversarial judicial process. Then under a civil law legal system, they apply this one, which has a very difficult name, inquisitional, whereby they do inquiries or investigations. So the judges themselves actually do what we call inquiries and investigations. So they investigate the matter, they carry out investigations. So before they can be able to give out the verdict. Under adversarial, that you are saying it is applied under a common law system, the defendant and the plaintiff, or the parties before the court, are given the liberty to be able to present their evidence and argue the facts by themselves before the court. So they argue the facts themselves before the court. So that's why they are saying under adversarial system, it uses a competitive, so the parties is like they are competing. The one who's actually able to present the best evidence is the one who will be able to win the case. Is the one who will be able to win the case. So he's the one who will actually be able to win the case. So kind of evidence, how he's actually able to argue out his case, is the one who will be able to win the case. So they just compete. But under inquisitional is where now, in this case, the judges or the juries who are to determine that particular matter, they put their head into that matter and do a lot of investigations, inquiries by themselves before they can be able to give out a verdict. And I think last time, you were actually able to look at the differences between an adversarial system and an inquisitional system, whereby we saw there was actually the emphasis whereby under inquisitional, the judge is actually quite much involved, or the juries are actually quite much involved in determining the matter. But under adversarial, it just depends with the parties. You have a defendant and a plaintiff, how they're actually able to argue and defend their case before that particular court. So the one who presents the best evidence, for example, is the one who will be able to win the case or impress the judge to be able to give the verdict in his or her favor. In his or her favor. So for example, here, you're having what you are calling the civil legal system. So the civil legal system, so these are the characteristics. I think we looked at them last time. So the civil legal system and the common law legal system. So the features, for example, for common law legal system are actually here. So there is no written constitution or formal documentation in terms of the laws guiding such kind of a system. So they rely on the common law. They rely on the common law. So judicial decisions are binding. Decisions of the highest court can generally only be overturned by that same court or through what we call legislation or case law. So they apply the case law. So there's extensive freedom to be able to contract, no formal laws in terms of contracts. So everything is actually permitted, that is not expressly prohibited by the law. So they don't have concrete laws in place to be able to guide their own functionings or how they can be able to conduct themselves or actually associate or maybe relate. But under a civil one, so there's actually a formally written constitution. So they have formal laws that have been crafted as to how they can be able to associate or actually conduct themselves. So that's why I was trying to explain that in a civil law system, it is like they are very civilized. They are very civilized. So they are very civilized. So they are basically able to govern their own affairs. They have even their own constitution that they have been able to craft or draft. They are actually able to, for example, set up parliaments. Parliament is there that has been set up to be able to legislate and formally come up with laws that are actually eventually enacted after having been signed into law. And you are saying under a civil law system, so under a civil law system is whereby you are saying they're actually able to apply what you are calling the inquisitional judicial process, the inquisitional judicial process. So whereby they carry out investigations or maybe inquiries before the judge is actually able to give the verdict. So if you go back to the question, so in most civil law jurisdictions, which of the following procedures may a civil appellate court generally perform? May a civil appellate court generally perform? So this is, for example, a situation whereby maybe there has actually been an appeal. So there has actually been an appeal, maybe in a civil law jurisdiction. So they'll have, for example, maybe to interview more witnesses or interrogate more witnesses, enter judgment if law issues are actually correct. So they just give a ruling if the issues are actually very correct. Or they can be able to collect more documentary evidence. They can be able to collect more documentary evidence. Collect more documentary evidence. Then we have the next question there. So which of the following is a civil litigation remedy? So is a civil litigation remedy. So you can have an injunction, you can have damages, you can have equitable relief. You can have equitable relief. So all the above are actually correct. So a civil litigation is basically where we are saying it is just a litigation involving or a matter before the court involving private individuals. So the civil law is the one that is actually being applied to resolve such kind of a matter. So it is a civil in nature. So civil, it is just between a civil lawsuit. A civil lawsuit, it is a suit just involving private individuals. What about a criminal lawsuit? A criminal lawsuit will likely involve the state and a private citizen or a private individual. So a civil litigation or a civil lawsuit is one that is actually involving wrongs having been committed between private individuals or private citizens. A criminal litigation is the one that is actually involving, it is a crime. It is a crime, for example, murder, for example, robbery, theft, violence. It is a crime that will likely involve the state and a private citizen. So under that one also, there'll be remedies that will be given or solutions that will be given by the court. In that case, they'll give punishments under crime. So for example, you can have a life sentence, community service. So you can have maybe in other places, maybe you can get maybe what we call they give what you can find out that they give what we call maybe a death sentence, maybe a life sentence. So in that case, it simply means that under civil suits or civil wrongs or civil litigations, they'll apply the civil law, and it could just be involving maybe matters concerning private individuals. For example, a breach of contract. For example, a problem under, for example, maybe marriage. For example, maybe a problem under, for example, maybe succession. For example, under succession. So the remedies, what they mean by the remedies here, they mean the solution that will be given by the court. For example, if there's actually a breach of contract, the court will give a solution. It will give a remedy. Which kind of remedy can they be able to give? They'll give an injunction order to stop the continuance of doing something in a particular way, or stop it completely from actually having to be continued. So that's what we mean by an injunction. If there's a breach of contract, that is what the remedy the court will be able to give. So they'll be able to apply the civil law. It will just involve matters concerning private individuals. So they can be able to give an injunction order to stop the continuance of doing something in a particular way, or they can give out what we call the payment of all the damages. The payment of all the damages. Or they can give out what we call an equitable relief, whereby the remedy given in this case, it is seen in wholly or in wholesome. It is seen in wholly or in wholesome to be fair to the parties, to be most reasonable to the parties, and equitable. It is equal, it creates equal balances between the parties actually affected. It is just quite fair that these particular parties, maybe they should just go their own way. They should just go their own way. So that is an equitable relief because they cannot be able to see eye to eye. So they cannot be able to contract. They can be able to maybe run a company together. So the equitable relief that can be given is maybe for the company to be dissolved. So that would be quite fair enough to the parties. So you can see in that case, it is involving disputes, for example, maybe this case under the law of contract, maybe law of succession, maybe law of marriage, it could be maybe law of tort, whereby, for example, someone has done what we are calling defamation, maybe there is negligence. So those are the kind of remedies that the court will likely be able to give. But if it is involving matters to do with the crime, criminal cases, then the reliefs or remedies that will likely be given would involve what we call punishment. So maybe death sentence, life imprisonment, community service. So those are the kind of things that will be declared by the courts. But if it is a civil matter, they won't give such kind of remedies. They won't go for such kind of remedies. They won't go for such kind of remedies. So under criminal matters, so death sentence, life sentences, fines and penalties, so all those will likely be issued as resolutions or remedies, or the verdicts by the courts, or the verdicts by the courts. So the next one is talking about the litigation process. So the litigation process. So 54. So the first phase of litigation process featured in most common law jurisdictions is referred to as the pretrial phase, the investigation phase, the examination phase. So the answer there was pretrial phase. So maybe I could ask, so which one do you think will actually be the first one? Which one do you think will be the first one under a civil law jurisdiction? Which one do you think will be the first one under a civil jurisdiction? So which one do you think will be the first one under a civil jurisdiction, civil law jurisdiction? So which one, who can be able to try? So that one is very simple. It's not very complicated. Investigation will be the first phase, because you are saying under a civil law jurisdiction, they apply which judicial process? Inquisitional. Under a civil law jurisdiction, which process do they actually, judicial process do they actually apply? Inquiries or investigations before the judge can be able to give a verdict. So it is quite obvious under that one, they basically start with the investigation phase. Investigation phase. So I give the order for both. I give the order for both. So maybe I can be able to get the order here. We go through it. The order for the judicial process. So maybe you can just go through the litigation process, or the whole litigation process. Then we can be able to see where exactly under a civil law jurisdiction it will start, and under a common law jurisdiction it will actually start. So let me share the process. the litigation process. So there are these main stages that can basically be seen to be in a litigation process. There's investigation, pleadings, discovery, pre-trial, trial, settlement, then you have appeal. So settlement and appeal. So under inquisition, or probably it will start, so they'll start from here. So all of these ones will likely be involved. But under adversarial, you're seeing that they'll be able to start from here. So they'll be able to start from here. So these are the ones. These are the ones will be under inquisition of the whole of them. So in the beginning stages of litigation, both parties involved in the situation require legal action should hire an experienced attorney or lawyer who will represent them well and work for their best interests. So they look, basically, people will look for maybe lawyers who have the experience to be able to protect or maybe safeguard them or give them guidance as to how they'll be able to approach that particular matter before the court. So the main stages of litigation will likely involve investigation, pleadings, discovery, pre-trial, trial, settlement, and appeal. So those are the main stages that probably are going to be involved in any kind of litigation. So, but it will vary from one litigation to the other. So investigation. Any cases in civil litigation start with the investigation stage. So a private investigator might become involved. So the main goal of this part of the process is to find supporting evidence for your side, to find supporting evidence for your side, to find supporting evidence for your side. So the main goal of this part is to find supporting evidence for your side of argument. This might include things like forensic evidence, medical records, or informal witnesses and interviews. So pleadings. So both parties involved in a lawsuit must file pleadings. Pleadings are initial documents that explain the basic arguments of either side of the legal issue. So this includes two parts. The complaint and the answer. The complaint and the answer. So the plaintiff and the defendant. So the plaintiff or the complainant presents, then the other party will likely be able to retaliate or answer back. So in the complaint, the plaintiff will file an official complaint. The plaintiff is the complainant before the court. So we'll file an official complaint with the court, which will be delivered to the defendant. So the complaint will be delivered to the defendant to retaliate back or give the answer. So this will describe the wrongdoings of the defendant and what specifically the plaintiff is holding them responsible for. So when the complaint is delivered to the defendant, this is called serving legal process or getting served. So once the complaint is filed, the defendant has the opportunity to officially answer or reply. So they may ask for further clarification on the issue or for corrections to incorrect allegations or legal understandings. So the defendant might even request that the court throw out the suit altogether if this feels strongly that it is actually unwarranted. It is actually unwarranted, or maybe there is no concrete evidence to pin them down. So in this case, we are saying that Azimio presents the petition. So the petition is now presented. The complaint is presented to the defendant. So the IEPC. So they retaliate back by presenting the answers. They present the answers in this case. So discovery. So the discovery process is the point in the litigation process where each of the parties involved attempt to discover as much as they can about the case. This This involves legal research, reviewing documents, interviewing witnesses, and more. Discovery is usually the longest part of the case and usually carries all the way up to the trial. The main elements of discovery are depositions, obtaining witnesses, and motions. Then we have pretrial. So what happens at the pretrial stage? The pretrial stage consists of meetings and negotiations between the attorneys for either side of the case. Many times, settlements will actually be reached during this pretrial period. Then you have now the real trial. So once the trial begins, either side argues their case before the court. So this might just include the judge or the bench trial, or a jury may also be involved, or a jury trial. So a jury is simply an expert who can be able to make a determination before a court of law. So before the trial, both the plaintiff and the defendant provide briefs to the judge. So these documents lay out the arguments they will make and the evidence that will likely be used. So during the trial, the following steps will likely be undertaken. So when choosing a jury, the opening statements, arguments, including questioning witnesses and evidences, introductions, all those, closing arguments, then the verdict of the judge. So then the settlement. So the settlement is the final outcome of the case. In civil cases, this is usually a sum of money that is paid to the winning party by the losing party. So once a judge comes to a final judgment, the settlement is owed to the prevailing party. So there can be some issues obtaining these settlements, however, during which the winning party can pursue collection or execution of what is owed to them. So the settlement is where now we are saying, for example, they give a remedy of an injunction, a remedy of damages. So that is the settlement that must basically be done by the defendant, must be done by the accused party or the defendant. Then there can be an appeal. You can be able to appeal. So maybe you didn't get a fair hearing in that particular court. You go to the next court. You go to the next court and actually you can do an appeal if you think you didn't get a fair hearing. So for example, now in this case, if you look at our court structure here in Kenya, so the highest court in the land is the Supreme Court. Then down there, we have the Court of Appeal. Then down there, we have the High Court. So maybe this matter was before the High Court. It was before the High Court. You think that you didn't actually get a fair hearing, or maybe your lawyers actually advise, your advocates actually advise that this was not actually a fair hearing. So there was actually, for example, maybe an error of the law by the judge in making the verdict or judgment or ruling. So you can go to the next court and actually appeal. So you can be able to appeal at the Court of Appeal. Appeal at the Court of Appeal. So you can be able to appeal at the Court of Appeal. So you can be able to appeal at the Court of Appeal. So these are basically the stages that will likely be involved, So all of them are likely to be applied in a common law or adversarial judicial process. So all of them are likely to be applied. So all of them are likely to be applied in an inquisitional process or a civil law system. So all of them, because under inquisitional is where we are saying, for example, they do investigations before maybe the case actually commences, or the real hearing or determination is actually made. So all of them will likely be involved under an inquisitional or a civil law system So, but under common law system is whereby you are saying that now in this case, so they'll be able to leave the parties to be able to argue the matters by themselves. So the judge is not involved in having to do the investigations or actually inquiries. And therefore now in this case, they'll start at the pretrial stage, So these are the processes of litigation. So I think I had not actually shared them on the group, so but let me share them. I have not shared them. So I've shared the documents. I think I've shared the documents. So that was the question. So under common law, so this one will be the first one. So under civil laws, they are likely to start with the investigation phase. Then question number 55, arbitration is an alternative dispute resolution where the arbitrator acts as, so he acts as a judge or a jury. So he's the one who will be able to give what we are calling an arbitration award. So he doesn't basically act as a third-party mediator. So I think here there was actually so this answer is the same as this one. So I think there's no difference. A judge or a jury. So I think this one I think are valid answers. So this one, so he acts as basically a person who can be able to give the final verdict, So judge or a jury. So he's not a third-party mediator. So a third-party mediator is the one who will likely be involved under mediation. So I think this one, we've looked at it, alternative dispute resolution mechanisms in detail. So which of the following procedures may a civil appellate court perform in most adversarial jurisdictions? So which of the following procedures may a civil appellate court perform in adversarial jurisdictions? So obtain more documentary evidence, obtain more witnesses' testimonies. So adversarial is where we are saying that in this case, the parties are actually left at liberty to be able to compete by themselves. So what could actually happen, for example, now in this case, in case there's actually an appeal, so obtain more expert opinions, obtain more documentary evidence, obtain more witness testimony. So I think these are the ones we saw here. So this one will be applied under inquisitional process. So these ones are going to be applied under inquisitional process. I think they just twisted the question. So these are the ones that are going to be applied under inquisitional process. So they'll be applied under inquisitional process. And not under adversarial process. So you can be able to note them down. So these are the ones that will be applied under inquisitional process in case of an appeal. So we can look at another one. So we can look at another question. So there's this one still under alternative dispute resolution mechanisms. So which of the following is an alternative method of legal litigation for recovering against losses caused by dishonest employees? So we have mediation, arbitration. So I think one that we've not discussed is the fidelity insurance. Fidelity insurance. So fidelity insurance is, for example, now in this case, where you for example insure or get an insurance cover for maybe recovery of all the losses caused by the employees of the company. Maybe it could be theft of items, or maybe theft of inventory, or maybe theft of money. So you can be able to get an insurance cover for such kind of losses that have actually occurred in the company. So you can get a fidelity insurance just to cover for any loss that is actually occurring as a result of a loss caused by the employees of the company. So there are those ones, maybe you might steal items and maybe leave the company without your knowledge. So how do you cover for that, for such? So you can be able to get what we call a fidelity insurance. Alternatively, you can just be able to get a mediator and actually agree with the employee for the amount to be recovered, or he actually pays for the amount by himself. Or you can be able to, the parties can be able to appear before an arbitrator. So maybe there's an arbitration body that has been set up by the employer. In case of such actually happens, then the parties can be able to appear before that arbitrator, who will be able to give a way forward. And of course, the employee can actually be deducted the amount, deducted the amounts. So maybe it is part of their policies. It is part of their policies as the employer. In case of such kind of a loss, then they have set up a resolution mechanism whereby there is a third party arbitrator who's actually able to resolve such kind of a matter. So you can be able to make a declaration that the employee should actually be able to pay for the losses, Then, so question number 66. So John filed a civil case against Jack, claiming that Jack breached in performing a contract that they had agreed and signed. Which of the following remedy would John likely to be seeking? So John filed a civil case against Jack, claiming that Jack breached what we are calling performance of a contract that they had agreed and actually signed. So which of the following remedy would John be likely to be seeking? So damages relief. So there are those remedies that can actually be given in case of a breach of a contract. So under damages relief, we simply mean that John would be seeking to be paid or actually compensated for all the losses that he has incurred in this particular contract as a result of the breach. So we can talk about damages. We can talk about being able to pay up to the extent the contract has actually been performed. So we call it quantum merit. So by quantum merit, we mean, for example, if you've hired someone to construct your house, so he has been able to construct up to maybe roofing level. So he hasn't done the roofing. So under the contract, you had agreed a particular sum of money. So you won't pay for the whole amount, but you'll pay up to the extent, up to where the work has been done. So maybe he had done the work up to that particular level, but he couldn't actually continue due to certain reasons. So you can be called upon to do what we call being able to pay for what has actually already been done. So it is known as quantum merit, or pay for the work that has already been performed under the contract. So another kind of relief that can be given, you can be able to talk about, for example, specific performance. You can talk about specific performance. So specific performance is whereby now in this case, the party is actually compelled to perform his duty as per the terms of the contract. To perform his duty as per the terms of the contract. Or there can be a relief known as an injunction. So whereby we are saying they'll be able to say they stop the continuance of performing or carrying out a particular role or task under a contract. So maybe I can be able to get those reliefs. I can be able to get those reliefs or remedies under breach of a contract. So remedies for breach of a contract. So you can have damages, quantum merit, specific performance, injunction, or maybe cancellation or rescission of the contract. So damages, so they are monetary compensation allowed to the injured party of the loss or injury suffered by him as a result of the breach of the contract. Then you have quantum merit. So it is a remedy for breach of a contract available to an injured party against the guilty party. So it literally means as much as is actually earned or in proportion to the work. It can be availed either without claiming damages or claiming reasonable compensation only for the work that you've actually been able to perform. Then we can have specific performance. So means the actual carrying out of the contract as agreed. So you'll be compelled to carry out the contract as agreed under the contract. So you can go for specific performance, but it's not always a best remedy or a good remedy in all circumstances. So where monetary compensation is adequate, so there won't be need for you to be able to carry out what we are calling specific performance. So I can see Mary saying she's taking short notes. So what I do, let me just extract this particular area. Then I think I can be able to share on the group. So I can be able to share on the group. So remedies for breach of our contract. So I've shared the notes there in the group. I think you'll be able to get them there. So I've been able to share. So you're saying we have damages, quantum merit, specific performance, injunction, and actually rescission or cancellation of the contract. You can decide to cancel the contract. So cancel the contract in case of breach. So specific performance is where basically the party is compelled to carry out his part of the terms, is part of the obligation or duties under the contract. So, but you're saying it is not always a good remedy in all circumstances. So where the court sees that, for example, monetary compensation can be an enough relief, so they don't go for specific performance. So they just go for compensation or monetary compensation. So where the court cannot supervise the actual execution of the contract. So they can't compel people to continue with that contract, yet the court cannot supervise. So they don't know what will happen. So maybe the breach will actually continue. So where the court cannot supervise, then specific performance is not a good remedy. It's not the best remedy. So where the contract is for personal services, e.g. a contract to marry or to paint a picture. In such contracts, injunction or an order which forbids the defendant to perform like a personal service for the other person will be granted. Then where one of the parties to the agreement does not possess competency to contract. So a person who is not actually qualified, doesn't have the experience to perform his roles or duties under the contract. If it appears such, then the court won't give a specific performance as a remedy. So they go for other options, maybe compensation or damages, or maybe quantum merits, so like that. Injunction, it is an order of the court restraining a person from doing a particular act, So it is the mode of securing specific performance of negative terms of a contract. So where a party is in breach of a negative term of the contract, where he's doing something which he promised not to do, the court may, by issuing an injunction, restrain him from doing what he promised that he will not actually do. So they give an injunction to stop doing what you had not actually promised to do under the agreement. So they give an injunction order to stop the continuance of doing such kind of a negative action or wrong thing under the contract. Rescission simply means that you do the cancellation or cancel the contract where you think that there's actually the breach of the contract. So you can decide to resign and just sit back without even having to inform the other party. So when there's breach of a contract by one party, the other party may resign the contract and need not to perform his part of obligations under the contract and may sit quietly at home if he decides not to take any legal action against the guilty party. So you might decide not even to take a legal action against the guilty party, but you can just cancel it out and just sit back home since you have discovered there's breach by the other party of the contract. He's not fulfilling his part of duties under the obligation. But in case the aggrieved party intends to sue the guilty party for damages for breach of contract, he has to file the suit for decision of the contract, So when the court grants rescission, for rescission of the contract, suit for rescission is supposed to be suit for rescission of the contract. So when the court grants rescission, the aggrieved party is freed from all obligations under the contract and becomes entitled to compensation for any damage which he has sustained through non-fulfillment of the contract, So they have given an example there. A contracts to supply 100 kg of tea leaves for 1,500 to B on 15 April. If A does not supply the tea leaves on the appointed day, B needs not to pay the price. So B may treat the contract as resigned and may sit quietly at home. So B may also file for a suit for rescission and claim for damages in a court of law. So for you to claim for the damages, then you have to sue the other party. You have to sue, but before you sue, you cannot be able to claim for the damages. But you can do what? You can be able to sit quietly at home. So you won't basically bother to even ask again whether the tea leaves are coming or they are not coming. So you just assume that so that was a failed delivery. You don't have to inquire further. So you basically just conclude that it was actually a breach of the contract. So long as you had agreed, it was supposed to be on a particular date, but it hasn't been delivered. So those are some of the remedies that will likely be given in case there's what we are calling a breach of contract, breach of a contract, or what we are calling under the contract law, law. So you can look at one final one. So question number 75. The jurisdictions that recognize corporate criminal liability can hold a corporation vicariously liable for the acts committed by which one of the following parties related to the organization. So what they mean by vicarious liability there, vicarious liability is simply where a person is actually accused of a wrong that is actually committed by another person or by another party. It is what we call vicarious liability. It mostly happens in a situation whereby you have a master and servant relationship. A master and servant relationship. So whereby we have the person carrying out the employment and the employee So for example, now in this case, you can be able to discover that if it is a corporate entity, then this is likely to be the employee. This is also likely to be the employee of that corporate entity, even an independent contractor under certain circumstances, but not actually always. That the wrongs of an independent contractor will likely basically be pegged on the employer or the master. So vicarious liability is one of the torts that you can be able to talk about, or a wrong that can be committed by a person against another party. So under vicarious liability, what happens? A person commits a wrong, but that wrong is actually blamed on another party. So the other party, we say the other party is held vicariously responsible or liable. For example, in this situation, we are talking about a master and servant relationship. If you are an employee of the bank, and you commit a wrong against the client will accuse the bank, your employer, vicariously for the wrongs committed by you as the employee. So even if he goes out there, he'll be saying that that bank is not the best. I'll never bank in that bank. In fact, I'm going to close the account. So you can see the wrong that has been committed by the employee. Maybe this employee didn't actually talk appropriately with the customer. Or maybe in this case, the employee abused the customer. But who suffers the repercussions? It is the bank, the employer. So vicarious liability is where a wrong committed by a person or a party is actually accused on another person, It mostly happens in a situation whereby we have a master and servant relationship. So in jurisdictions that recognize corporate criminal liability, can hold a corporation vicariously liable for acts committed by which one of the following parties related. So you can be able to see they're talking about related. And I'm talking about, in this case, it happens in a master-servant relationship. So this legal counsel can be the employee of the corporate entity. These directors are employees of the corporate entity. The corporate entity can also engage an independent contractor, maybe to carry out a particular role on the behalf of the corporate entity. So the wrongs that are normally done by the directors, who will be held responsible? It is the company itself, the employer. the company that has employed these directors, if they commit any wrong because they act as, for example, in this case, entering into deals, transactions, contracts on behalf of the company. So if these contracts are not actually successful, the person who's going to be blamed for the wrongs that were done by the directors, it is the company, the employer. If it's a legal counsel or a lawyer of the company, while acting in his capacity as the lawyer of the company, commits any wrong, the person who's going to be held vicariously liable, it is the company itself. If it is an independent contractor working exactly under the instructions of the employer or the master, the wrongs committed by the independent contractor will be blamed on the company itself or the corporate entity itself. So the corporate entity or the company will be held vicariously liable. So the key elements in a vicarious liability, there must be a master-servant relationship. Number two, this servant must have committed that wrong while in the course of employment. This legal counsel committed that wrong while in the course of employment on behalf of the company. The directors committed the wrongs while they were carrying out the duties as they are supposed to be able to carry them out as per the instructions or mandate under the company's articles. So this independent contractor was working or carrying out a task under the instructions of the company as the master. So number one key element, it happens in a master-servant relationship. Number two key elements, it must have happened, that wrong must have happened, that liability must have happened while in the course of employment. So all these parties can be like employees of the company. Can be like employees of the company. So maybe I can be able to share something about vicarious liability. So just on the group there. So let me get it. Let me share something about vicarious liability. I think I've shared there, so I think you'll be able to see on the group there, vicarious liability. So there are circumstances, however, that another person may be held liable for torts committed by another. So this is referred to as vicarious liability. It mostly tends to occur in employment scenarios. Like that scenario in that question, you can be able to see it's an employment kind of whereby they have employed the legal counsel, they have employed the director, they have employed the independent contractor. So the following key elements must exist: master-servant relationship. Servant must have been acting in the course of employment. The servant must be under the control or working under the instructions of the master. So long as they did this wrong while they're under the mercies of the master or the instructions or control of the master, then the master is the one who's going to be held vicariously liable. Is the one who's going to be held vicariously liable. So I think that is what we mean by vicarious liability. That is what we mean by vicarious liability. So I think for today, I think we can end there with our revision. So we can end there with our revision. So all those areas that we covered that you didn't have, the notes, I think I've been able to share on the groups. I think you'll be able to access them. So you can continue to revise them. You can continue to revise them. So I don't know if there's actually any concern or any question up to that particular point, because I would wish to end the class there for today. I would wish to end the class there for today. So read consistently, so don't stop reading until exam time, so that you'll be adequately prepared. You'll be adequately prepared. So you can't find the notes in the group, so I don't know why you can't see them. So I don't know if Martha is able to see those notes I've shared there. So Martha, are you able to see the notes I've shared on the group? What about Agade? Are you able to see? There are some notes I've shared there a while ago. You should be able to see them. I can see Martha says yes. So they should be there. So I don't know why Mary is not able to see those notes. I can see Agade is able to see them. So I don't know why Mary you are not able to see, or you are in the wrong group. You can see Mary. Mary, you attended the wrong class or what? So this is a class for CFFE. It's for CFFE. I don't know how you found yourself here, or so you want me to do a recap of the types of laws. So I think I'll be able to do that recap maybe in our next class. So if there's no any other concern, then I think we'll be able to meet in our next class. So I wish you a nice weekend.